Major breaking news out of the United States Court of Appeals for the 10th Circuit in Denver, which heard oral arguments this morning over whether or not the governor of New Mexico, that's Michelle Grisham, whether her order to ban guns in parks and on playgrounds is constitutional under the Second Amendment. Major oral argument. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling book, Israel Disarmed: What the 10/7 Attacks by Hamas on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon. All right, major oral argument today in consolidated cases in the United States Court of Appeals for the 10th Circuit based in Denver, Colorado, overseeing the state of New Mexico. The captions of the case are Randy Donk, as well as We the Patriots et al. Versus Michelle Grisham, the governor of the state of New Mexico. Many Second Amendment-related advocacy groups, including the Second Amendment Foundation, the Gun Owners of America, and the Firearms Policy Coalition, were all involved in this case. Consolidated cases. As you may recall, Governor Grisham came out with an emergency order because there was increased violence in certain counties in New Mexico, to say that there would be no guns on playgrounds and no guns in parks. We're not going to break down sort of the procedural posture here, but I will say one thing. One of the things we've talked about on this channel before is the importance of not only understand the substance of the Second Amendment, meaning the text and the history and the meaning of the Second Amendment on the merits. It's in many respects equally important for we in the Second Amendment community to understand the process and procedures whereby Second Amendment cases are litigated in court. Today illustrates the point because the first set of questions from this set of judges, and we'll get to the Second Amendment in one moment, but it's very important to understand that the first set of questions for several minutes, taken up several minutes, by this three-judge panel on the 10th Circuit and based in Colorado, was about whether or not the plaintiffs had standing and whether or not their case was moot and whether or not they needed to decide the case because whether or not there was a prior order that somehow impacted the rights of the plaintiffs in these particular cases. Now, we're not going to get into this because it's not necessary for the purposes of this, beyond saying that the judges raised legitimate questions about whether or not they even needed to decide this case because it seemed to be that the Second Amendment plaintiffs were already protected, allegedly, by already existing preliminary injunction orders applicable to them. Although there appears to be some question mark about the scope of these and whether or not the plaintiffs in these two cases of Donk and We the Patriots are covered, that was a set of questions that the judges asked. So it just illustrates my point that process and procedure and how cases wind their way through the courts is also important for we in the Second Amendment community to understand. So we get it right and don't get kicked out of court on procedural grounds because we always want the merits of a Second Amendment claim to be heard. All right, well, let's carry on. So what happened today, other than the big discussion about whether or not the case was moot, whether it could be redressed, whether there was redressability or standing questions, there was a serious debate about the merits of the Second Amendment. And this three-judge panel, which appears to be kind of agnostic, and what I mean by that is none of the three judges had a particular history involving the Second Amendment that I could tell. They asked a lot of smart questions, and I thought overall New Mexico got the worst of the fight. In this fight, I thought the Second Amendment arguments in favor of the Second Amendment were much stronger than the arguments advanced by New Mexico, and it seemed to me that the judges agreed with the proper view of the Second Amendment and not the government of New Mexico's view. For example, there was a discussion about whether or not the proper time period for interpreting the Second Amendment was 1791 when the Second Amendment was adopted, or 1868 when the 14th Amendment was adopted and applied the Second Amendment and the rest of the Bill of Rights to the states and to local governments. And as you know, and in fact, I took a look at the briefs, it turns out that the lawyers in support of the Second Amendment actually cite to two separate scholarly articles of mine, including the article where I lay out in extreme detail, and I think this is clearly the right answer. The 1791 is the proper time period for measuring the Second Amendment, and I think this three-judge panel was quite familiar with my positions because they asked a lot of questions that seemed to indicate they understood exactly what I was saying in that article in the Harvard Journal of Law and Public Policy, which they basically, although they didn't mention me by name, they discussed these theories during today's oral argument. And the state of New Mexico, as you know, as I predicted, weighed heavily in and depended entirely upon using late 19th century laws dealing with bans on guns in parks. in the late 19th century. And the judges immediately jumped in and said, wait a minute. But this assumes that we're going to look at the late 19th century to interpret the Second Amendment, which was adopted in 1791, 100 years earlier. And the lawyer for the state of New Mexico and for the governor, right, for the defendants, was, of course, basically saying, well, that's the relevant time period, we think. But, of course, what happens is the judges say, well, that seems a little bit of a stretch. This is my interpretation of what the judges were indicating. We are required to interpret the Second Amendment equally, coterminously, the same, whether we apply the Second Amendment against the federal government and federal gun regulations or whether we apply it against state or local gun regulations. According to the U.S. Supreme Court, the Bill of Rights, whether it applies to the federal government or to the states, is supposed to be the same. And the lawyer for the government for the defendants, we have the governments, really try to emphasize again the late 19th century, but the judges did not seem to be buying it. They said, well, it seems to be a little bit late in time. It seems to be that we have to interpret these at the same way, and to do that, we have to look at the 18th century, which is 1791. So I don't think that that's going to get them very far with the state of New Mexico. Beyond that, there was a discussion about what is a park. Now, the government of New Mexico, or I should say the government defendants here, were trying to say that parks did not come into existence in the United States till the late 19th century, and that's why the late 19th century is appropriate to look at. But the Second Amendment plaintiffs said that no, Boston Common and many other places in New England, for example, in the 18th century, before the founding of our country, effectively had parks. Whether they were labeled as such or not is a separate question, but you had grazing areas where people could graze animals, they could have recreation, they could play games, they could run around, they could do all sorts of things. So there were effectively parks in the 18th century, but there was no examples of gun regulations on those parks in the 18th century. And that goes back to the point I was making, which is why the late 19th century is the time period that the anti-gun movement must win, and I don't think they're going to be able to ultimately do it. They must win because there's a lot more gun-related regulations. For example, the government defendants argued that there were a lot of gun bans on parks in the late 19th century. And therefore, those are appropriate analog laws to justify the existence of an alleged historical tradition of firearms regulation banning guns in parks. But the judges asked a very powerful question and said, wait a minute. I thought a lot of these parks in the late 19th century also banned effectively other constitutional rights, such as you could not swear, you could not speak loudly, other issues that we would consider perfectly fine constitutional behavior. You were not allowed to do those in the late 19th century because they were trying to create this aristocratic set of parks where you couldn't do anything in the parks. And again, if you think about it, in the late 19th century, if you ban swear words, loud talking, sermons, whatever, in addition to banning guns, which you've essentially said in these parks in the late 19th century, which is, again, is too late in time in my view, and I think in the Supreme Court's view. What you're basically saying is that the entire Bill of Rights is repealed in public parks in the late 19th century. Because, again, it wasn't just you couldn't bring guns onto the property. It was you also could not exercise First Amendment rights or step on the grass and all sorts of other crazy rules that dealt with these parks that would never be acceptable today or in the 18th century. So I thought that was a pretty good rebuttal by the Second Amendment plaintiffs. Beyond that, it also bears mentioning that there is a big discussion about schools. Now, this is where you get into some of the technical issues. There was a prior 10th Circuit decision that said that the Heller language that says that schools are sensitive places and you could ban guns there, that is dicta and binding on the 10th Circuit. But I thought the Second Amendment lawyers did a good job rebutting that by pointing out, which is the right answer, that, yeah, you look at the Heller dicta, but then it was modified by the Bruin decision, which really narrowed down the specific types of government buildings. And just to jog your memory, in Heller in 2008, the Supreme Court said that nothing about the Heller decision suggests that it is unconstitutional to ban guns in sensitive places like government buildings or schools. But then in 2022, in the Bruin case, when they talk about sensitive places more specifically, and they elaborate a little bit on it, they only illustrate 3 places that are presumptively sensitive. In Bruin, they say polling places, legislative chambers like the halls of Congress, and courthouses. So the argument there is whether or not the generic reference to government buildings and schools in Heller has somehow been modified by the very precise specific examples given in Bruin, in addition to the language that says you are allowed to and must reason by analogy from these 3 places. So the government defendants here are just trying to say that just embrace Heller's dicta, and that's the end of the analysis. The Second Amendment plaintiffs are saying, no, that's not enough. You must draw analogies from these three places articulated by Bruin, because the Bruin language involving sensitive places modified and clarified what they meant in Heller. So yes, you're maybe binding on, the 10th Circuit maybe have to follow dicta, but the new dicta dealing with sensitive places that's binding would be Bruin, which tells you, again, three specific places are sensitive, and you must rely on analogies if you want to find other places to be sensitive. Now, I think the judges actually got this, because one critical question that the judges asked is something we've talked about on this channel, which is the time of the founding, to the extent there were bans of guns in schools, which arguably is analogous in this case. Now, the reason why this school dicta from Heller and the references to sensitive places of Bruin is so important is it deals with the sensitive place, allegedly so, identified by, by Governor Grisham, dealing with playgrounds. So the state and the government defense are trying to say that the playgrounds are analogous to schools. But again, I thought the Second Amendment plaintiffs did a good job here arguing that, well, the playgrounds is a very fuzzy and ambiguous term, because the emergency order by the governor dealing with no guns on playgrounds is not clear as to whether or not, what is a playground? Is it a school playground on school property? Is it a playground that you might find in a McDonald's or fast food restaurant? Is it a playground one might find in a mall? And because it's unclear, it's not even clear that the reference to schools as a sensitive place in Heller even applies, for example, to a playground in a fast food restaurant or in a mall. But either way, one of the judges asked a critical question. I think this is a good tell that he's leaning in our favor. In this case, he specifically says, well, wait a minute. Going back to the 18th century, which is, of course, the right century, because that's when 1791 falls, and that's when the Bill of Rights was adopted, including the Second Amendment. So that's a time period you should be looking at. The judge says, wait a minute. At the time of the founding, if you look at these bans at schools, these were bans on the students from carrying arms. And then discusses something we've talked about on this channel, which is the in loco parentis doctrine. So the judge basically said, wait a minute. So students were banned from carrying guns, but we're not talking about guns and students in this case. We're talking about adults who are responsible for their own defense. Moreover, the principle or the theory that justified banning guns among the students at colleges, for example, in the 18th century, was the in loco parentis doctrine, which basically said that because the students back in those days, the students were so young, they were like 15, 16 years of age when they went to college. Back then, the faculty and the teachers and professors at those universities functioned in loco parentis, meaning they were like the parents of the college students. That is certainly not the case today. And again, the plaintiffs in this case are not students. They're adults who are responsible. And there is no, none, zero, nada 18th century precedent for banning guns in schools for anybody other than the students themselves, who at the time were 15, 16-year-old children, really. Likewise, the reason why the Boston Commons issue comes up when it comes to parks is because there were zero, none, nada rules that banned guns in parks in the 18th century, even though these areas of commons were not labeled parks. The word parks doesn't become really popular in the Western world until, or at least in America, until the late 19th century. But that doesn't mean that you did not have places that functioned as parks in the 18th century, which of course you did. Boston Commons is a great example. Those where people use that not only to graze animals, but also to engage in recreational conduct and stuff like that, and militia musters. The last point I want to bring up is the government defendants on behalf of the governor argued that a lack of historical laws doesn't mean they lose, but that's not right. Remember, the Bruin methodology, which is Heller-Bruin, says that once the text is implicated, which obviously if you can't bring a gun somewhere, it's implicated, the right of the people to keep and bear arms. If you can't bring a gun in a place, your right to bear arms is infringed as a matter of text, as text. So then the burden shifts to the government to show a historical tradition of firearms regulation. So the government defendants here were trying to say that the lack of regulations, the lack of laws, does not in and of itself allow the Second Amendment community to win, but that's clearly not true for two reasons. One is, the burden is on the government to show the existence of, listen carefully, the existence of a historical tradition of firearms regulations. If you don't have any firearm regulations, then obviously you cannot use nothing to drive something, right? So if you have no firearms regulations involving public parks at the time of the founding, if you have no firearm regulations that applies to adults or teachers or faculty members at the time of the founding that go to school, and no regulations involving firearms on playgrounds or anything like that, there's nothing to derive a historical tradition of firearms regulations. You have to actually have regulations to derive a historical tradition of regulations. If you have no regulations, you don't have a historical tradition of regulations because there are no regulations. Hello, this is not that hard. Now, the defendants were trying to argue there's some notion of principle, but they were just such a generic level of principle that doesn't make any sense, especially if you look at Bruin, where there's two critical pieces of language in Bruin that we must always remember. In Bruin, they specifically say, where they're dismissing an argument brought back in Bruin by the state of New York, they specifically say that 3 regulations are not enough to cause or create a historical tradition. Did you hear what I just said? The Supreme Court in Bruin said that 3 laws are not sufficient to create a historical regulation because New York had referred to 3 different laws allegedly in 3 different states, and that was not enough. So if you have no laws, obviously that's fewer than 3 laws, even under new math and Common Core. Okay? 0 is smaller than 3. So if you have no laws, you lose because 3 was not enough in Bruin. Beyond that, we know from, I think, footnote number 6, dealing with the Sir John Knight's case. There's a discussion about what was the significance of an Old English case called Sir John Knight's. Okay? Now, what the Supreme Court said in a footnote was, to the extent there's any ambiguity, and listen carefully, this is important, to the extent there's any ambiguity in the historical record, the government loses because the text prevails. So the government bears the burden to win at the historical level, and if there's any doubts or questions about whether or not there's no laws or there's an ambiguous set of laws, meaning it could go either way, 50-50 if you will, the government loses because the government bears the burden to show a historical tradition of firearms regulation. So to the extent there's a debate about whether or not the Boston Common or these other alleged parks or non-parks of the 18th century were parks or not, to the extent there's ambiguity about that, it's not that hard for judges to figure it out. If there's unclear, the government loses because the government bears the burden. And when the government cannot overwhelmingly demonstrate that there's a historical tradition of some sort of regulation, the text of the Second Amendment wins because the text of the Second Amendment was referred to by the U.S. Supreme Court as the unqualified command. When in doubt, the text wins. And we win as American citizens. And our right to keep and bear arms wins as well. All right, folks. Well, we'll let you know. I'll try to get a copy of the audio tape here off the internet and try to maybe splice and dice it so you can listen to some of the argument in a couple days. And make sure if you're going out to San Diego for the Gun Rights Policy Conference, sponsored by the Second Amendment Foundation, make sure you stop by and say hello. I'll be doing a couple of events out there as part of it and doing some talking. And make sure you stop by and say hello. And don't forget to follow me on X at 4 Boxes Diner. And we will see you again very, very soon, I hope, here at the 4 Boxes Diner.
Orders up. Table 2A.